You just spent years and millions of dollars securing a favorable arbitral award at the LCIA in London, the SIAC in Singapore, or ICC in Paris against an Indian corporate entity. Under the New York Convention and Part 2 of the Indian Arbitration and Conciliation Act 1996, the foreign award is supposed to be immediately enforceable. Your client is relieved. But when you bring that multi-million-dollar award to the Indian jurisdiction for execution, you realize a terrifying truth. Your award is rapidly turning into a paper tiger. Hi, I am Advocate Ashish, Rishi, Managing Partner at Northwest Legal Consultants, India. Today, I am going to decode the exact multi-layered situatory blueprint our cross-border litigation desk uses to bypass the local judicial delays, paralyze Indian defaulters, and turn your foreign arbitral award into liquid cash. Let us understand why standard enforcement fails in India. It is a masterclass in judicial delay. The moment you file for execution, the defaulting Indian promoters will instantly file a resistance petition under Section 48 of the Arbitration Act. They will argue that enforcing your award violates their fundamental policy of Indian law or suffer from patient illegality. Even though the 2015 commercial amendments strictly narrowed the scope of judicial intervention, the reality of overburdened Indian court remains. While the civil courts debate these frivolous objections for the next 3 to 5 years, the Indian promoters are executing their real strategy: systematic asset dissipation. By the time you finally secure an execution decree under Order 21 of Indian Civil Procedure Code, the Indian entity is a hollow shell. The bank accounts are drained, the assets are stripped, and your client is left holding a worthless piece of paper. Most local councils in India make a fatal jurisdictional error. They file an execution petition and passively wait for the judge to issue a show cause notice. At Northwest Legal Consultant, we do not wait. We strike first. Before the defaulting entity is even aware of the enforcement strategy, our execution ground force deploys Section 9 of the Arbitration Act. We move the commercial division of High Court for urgent ex parte interim protection, effectively seeking the Indian equivalent of a Mereva injunction. We do not ask for the enforcement of the award. We demand immediate primitive attachment of the defaulters' corporate bank accounts and their commercial real estate. Furthermore, we deploy garnishee orders. Under Order 21, Rule 46 of the CPC to legally freeze their third-party receivables and incoming cash flows. When an Indian promoter wakes up to find their working capital paralyzed and their letter of credit blocked by a high court writ, their public policy defense is instantly abandoned. We force them to settle table within days rather than decades. Now, what if the promoters have already initiated fraudulent transfers? What if corporate veil is being used to shield siphoned funds? This is where standard civil litigation dies and elite corporate warfare begins. Through aggressive forensic asset tracing, we establish Animus Fraudendi, fraudulent intent. We petition the court to pierce the corporate veil, stripping the directors of their limited liability protection. We legally attach their personal mansions, private equity holdings, and personal bank accounts to satisfy your client's foreign award. Furthermore, we weaponize situatory framework. If the arbitral debt is acknowledged, we deploy the Section 8 situatory demand notice under the Insolvency Bankruptcy Code IBC 2016. And if the defaulter involves international trade, we concurrently report these fraudulent cross-border remittances to the Enforcement Directorate under the Foreign Exchange Management Act, FEMA. Now, the Indian promoters are not just fighting a civil execution, they are facing corporate insolvency and severe regulatory probes. To all the international law firms, foreign arbitration practitioners, and global general counsel watching this, the Indian legal system has a strong pro-enforcement bias, provided you that the right executors navigating it. Do not let your hard-won arbitral award die in the backlog of Indian civil courts. You did a heavy lifting in London, Geneva, or Singapore. Let us execute the situatory squeeze play in India. At Northwest Legal Consultants, we do not practice law to debate. We practice law to execute. If your firm is sitting on an unenforced foreign award, or if your client is facing resistance from a defaulting Indian entity, route your case directly to our international legal desk at legal@nwlc.in. We assess the jurisdictional risk, we trace the assets, and we secure the funds. This is Advocate Ashish Rishi. Thank you for watching and looking forward to safeguarding your client's cross-border interests. Have a great life ahead.